Welcome everyone to our afternoon hearing on Tuesday, March 12th, 2024, 2 p.m. This is the House Committee on Judiciary and Hawaiian Affairs. We're in conference room 325 and we're having this hearing by video conference as well. For those who are testifying, I would ask if you could keep their testimony to 2 minutes, and I'll ask you to summarize at that point. If you're testifying via Zoom, please keep yourself muted and your video off until you testify, and then mute yourself and turn your video off after your testimony is complete. If you need to ask some technical questions to the technical staff, who are doing a great job, thank you, just use your Zoom chat function, and you can send a message to our technical staff and they can help you out as best they can. Don't send me any messages though. I don't get those messages. If you are disconnected, don't worry about it. Try to rejoin yours, and then we'll fit you in when you come back. If the power goes off in the building here or network failure or something and we have to reschedule, I'll make sure to post appropriate notice so everyone knows when we're going to have decision making or continuation of our hearing. If you're testifying on Zoom, please avoid using any trademarked or copyrighted images, and please everyone conduct yourselves with aloha, no profanity or uncivil behavior. It's okay to disagree, but let's not be disagreeable. Okay, let's go ahead and get started on our measures today. First up, Senate Bill 2520, Senate Draft 2, relating to the defense of state employees. This measure requires the state to defend professionally licensed or certified state employees from civil actions when the employee was acting within the scope of their employment and was not grossly negligent or wanton or failing to cooperate. Clarifies that the employee may employ their own attorney at the employee's own expense, and requires that if the state refuses to defend a state employee from civil actions on certain grounds, the Attorney General shall first work with the employee to amicably transfer representation to the replacement counsel and file a motion to withdraw as counsel as a confidential document. First up, we have testimony from Hawaii Government Employee Association. Welcome. Please introduce yourself and proceed.
Good afternoon, Chair, Vice Chair, members of the committee. Steve Tevis for Hawaii Government Employees Association. We stand in strong support of the current measure. If the Chair and Vice Chair remembers, this was a bill from last year that got all the way to conference. I think we have an agreement on the language with the Attorney General's office, so we respectfully ask that you pass this on. Thank you, Chair.
You want to highlight why you think it's a good idea?
Well, as from last year is, in the past, the AG had total discretion on whether to represent an employee or not. This, and with agreement of the AG, and we compliment the AG, if that decision is made by the Attorney General's office, it's left up to a court of law to decide. The AG would have to file a motion, and the judge would decide if it's appropriate or not for the AG to represent that, or to withdraw from representing that employee. And we think that's fair on all sides, and that's why we support it and ask for your consideration.
Okay, thank you very much.
Thank you, Chair.
Next, we have testimony from the Hawaii Association for Justice in support, and Hawaii State AFL-CIO in support. That's all the testifiers I was told are wanting to testify. Is there anyone else here wishing to testify on Senate Bill 2520? If not, questions, members? Questions? No. Okay, thank you very much. We will move on to the next measure, Senate Bill 2683, Senate Draft 1, relating to defamation. Protects individuals who make claims of sexual misconduct from defamation lawsuits unless the claims were proven to be made with malice. On this measure, first up, we have the Hawaii Civil Rights Commission providing comments. Next, we have testimony from the American Association of University Women of Hawaii, providing supportive testimony. Next, we have testimony from the Hawaii Women Lawyers in support, and testimony from Kapalama Neighborhood Security Watch in support. Anyone else wishing to testify in Senate Bill 2683, Senate Draft 1? If not, questions, members? Seeing none, we'll move on. Thank you. Senate Bill 2758, Senate Draft 1, relating to sex trafficking. This bill authorizes civil claims to be made against a business, owner of a business, or operator of a business that profits from sexual exploitation. On this measure, first up, we have testimony from the Attorney General. Justine Hura, Deputy Attorney General. Welcome. Please proceed.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Justine Hura. I am a Deputy Attorney General, and I represent the Attorney General's office in this matter. We respectfully submit that the only issue at this point in this particular piece of litigation, our comments, are that
Legislation. We're not litigating.
Sorry, thank you. In this legislation, yes, and that the only issue that we had was abolishing the statute of limitations, as the bill proposes, that this may create potential due process or evidentiary issues for future litigants, and whether or not these issues can be justly surmounted. Eventually, the filing of a lawsuit implies costly litigation on potentially very stale matters, and those are our comments. Thank you.
Thank you very much. Appreciate you sticking around. We might have some questions.
Very well.
Thank you very much, Deputy Attorney General. Next, we have testimony and support from Rainbow Family 808, testimony and support from Imua Alliance, and testimony and support from two individuals, Christine Johnson and Leimomi Khan. Is there anyone else wishing to testify on Senate Bill 2758? If not, questions, members? I have a question for the Attorney General's office. On this matter, in your testimony, you're just saying making it open-end with no limitation is not a good idea. If we were to put a limitation on it, extend it, I mean, right now it's 6 years, right?
Yes.
So I'm considering extending it to 10 years and reinstating the tolling provisions. Would that in large part address your concerns?
Yes.
Okay, thank you.
Thank you.
Appreciate it very much. Okay, any other questions? If not, let's move on to the next measure. Senate Bill 2439, relating to limitation of actions. This measure extends the statute of limitations for civil actions brought by persons subjected to sexual offenses as an adult against the person who committed the act. Revives for a 4-year period certain actions for which the statute of limitations had previously lapsed. It allows a claim to be brought against legal entities during the 4-year window period if there is a finding of gross negligence. And the measure authorizes a court to award attorney's fees to a defendant when an accusation of sexual abuse was made with no basis in fact and with malicious intent. First up, we have testimony from the Attorney General's office. Lee Young-Kwok, Deputy Attorney General.
Yes, thank you. Good afternoon, Chair Tarnas and members of the committee. I am Deputy Attorney General Lee Young-Kwok, and I represent our department with respect to SB 2439 SD1. While our office does not discount the right of survivors of sexual abuse to initiate lawsuits, we do have concerns with the proposed new section to Section 657, which would introduce a 4-year period of free and open litigation against the state that disregards any applicable statute of limitations. As reflected in our written testimony, the integrity of evidence becomes strained when we have cases that are 20, 30, 40, even 50 years old, or any number of years old, which this bill would allow. Under these evidentiary constraints, it becomes next to impossible for the state to defend lawsuits of this nature. To give some context, the type of sex assault lawsuits that my division handles usually follows this format. The plaintiff or the victim of the sexual abuse sues the state, alleging some kind of supervisory negligence of the employee who is accused of perpetrating the sexual assault. The plaintiff does not actually sue the alleged perpetrator because the perpetrator is already dead or they don't have money and are therefore not worth suing in this capacity. With the alleged perpetrator gone and witnesses from decades prior being deceased or relocated or otherwise missing, the state has no witnesses to refute the plaintiff's allegation and defend its case. If the state cannot rebut its case, a mere allegation may be sufficient to allege damages, and these are damages which the state will have to pay for. If the committee is still inclined to pass this bill, our suggestion is to scale the 4-year period back to a more reasonable 1-year period, which was what was proposed in the original bill. And within that 1-year period, institute a 15-year statute of limitations, which is what we think is a reasonable expansion from the current 6-year SOL for sexual assault lawsuits. thank you for the opportunity to comment.
Thank you very much. Next, we have testimony and support from the Stonewall Caucus of the Democratic Party of Hawaii. Mr.
Good
Golio,
afternoon.
please proceed.
Thank you, Chair. Michael Gloria Jr. on behalf of the Stonewall Caucus of the Democratic Party of Hawaii. We stand in strong support of this legislation before you. Other jurisdictions have done this. They have not had problems. I don't understand why our Attorney General keeps on fighting this back and forth on this issue with making sure survivors have a chance of their day in court. We know that the scrutiny when it comes to bail for these damages is much lower than when they can going before if they were to be convicted of a crime. So that at least in some way, the survivors have an avenue of seeking justice. As we saw with Eugene Carroll, being able to go back and be able to get justice because the state of New York has already provided this opportunity to her to be able to seek justice there. This is what we're looking for here. And the Attorney General has access to much more resources than anybody else, but to be able to reach out and find out how other jurisdictions handle this, that it will not cripple our jurisdiction, this jurisdiction. As we saw, it did not cripple them when we had this, the testing period for the statute of limitations removal for minors. So this is a much needed bill. We need to be able to protect our survivors, believe survivors, as we saw during the Me Too movement, that people were, survivors were silenced, scared into silence, and they should be able to give them this opportunity. And a 1-year window is not fair at all to them. And that 4-year window, I think, is a nice, it's not what we'd actually really like to see, but it's a good starting point and a fair one that was negotiated out. So I encourage you to pass this bill. Mahalo.
Thank you very much. Next, we have testimony and support from the Hawaii Association for Justice. Next, we have testimony, and that's in support. We have testimony and support from Rainbow Family 808. Testimony and support from the organization RAIN, Rape, Abuse, and Incest National Network. Testimony and support from another individual with Rainbow Family 808. And testimony and support from numerous individuals, Terry Heedy, Luann Mahiki, Lankford Favorito, Christine Johnson, Alika Valdez, Rebecca, and Renee Rabb. Is there anyone here or online wishing to testify on this measure? If not, questions, members? Any questions? I have a question for the Attorney General, if I may. One of the other testifiers, the Hawaii Association for Justice, recommended an amendment to remove the word gross to make the threshold for a claim for damages against a legal entity to be just negligence rather than gross negligence. That, as a non-lawyer, that seems like it's significant. Could you explain the significance of what that change might result with?
So removal of the word, of the requirement for gross negligence, it is a higher standard to which someone is held accountable for their conduct, speaking.
Gross negligence is a
very
higher standard.
generally. Yes. So if someone is grossly negligent, that means their negligence is much greater than just regular negligence. So to be able to show that gross negligence means that as a defendant, you would have to show that their negligence is far ahead of just normal negligence in order to pursue litigation against that party. In a nutshell is what it means.
And would you advise that's a good idea to adopt that amendment or not?
I'm sorry, I didn't address this part of the bill in my testimony, so I'm just very quickly looking at what our formal position is on that.
If you need to say you don't know, that's okay.
Yeah, we can definitely get back to you with our formal position on that.
Well, if the
Terminology.
committee decides to move this along, it'll go before the next committee, and I expect that this Hawaii Association of Justice will probably make the same recommendation, so it might be worthwhile for you to consider that. We'll see what this committee will decide to do with this measure, but I wanted to ask your opinion about it.
Okay, we can certainly follow up also with the chairperson of the next committee
Okay.
regarding our formal, opinion on that.
And you can look at the testimony from Evan Oy with the Hawaii Association of Justice to see
Yes,
their
we understand
recommendation.
they've submitted testimony to their position on multiple bills of this nature.
Okay.
So, thank you.
Okay, great. Thank you very much. Any other questions, members? If not, thank you. We'll move on. Senate Bill 2601 relating to sexual abuse of minors. This measure expands the time period by which a civil action for childhood sexual abuse may be initiated. It authorizes a court to require personnel of legal entities to undergo training on trauma-informed response. First up, we have Attorney General Lee Ying Kwok, Deputy Attorney General.
Good afternoon again, Chair Tarnas and members of the committee. I am Deputy Attorney General Leanne Kwok, and I represent our department with respect to SB 2601. We're going to go ahead and incorporate our arguments from the testimony given in the previous bill, SB 2439, at least with respect to cases centered on sexual abuse that have happened quite a long time ago. We would like to add that if the committee is still inclined to raise the time period of the SOL, our formal suggestion is to raise it from 8 years to 15 years instead of 32 years. We believe this less extensive period will ensure a greater likelihood that the plaintiff or the victim will be actually able to face their perpetrator to demand justice instead of suing large parties that are only tangentially associated with the perpetrator. We also believe that this less extensive period will make it more likely that documents are still in existence to be used as evidence in state's defense, and that there will also be witnesses that the state can use in their defense. Thank you for the opportunity to comment.
Thank you very much. Next, we have testimony and support from the Sex Abuse Treatment Center, Executive Director Lynn Costales Matsuoka.
Yes. Good afternoon, Chair, Vice Chair, and members of the Judiciary and Hawaiian Affairs Committee. Thank you so much. My name is Lynn Costales, and I am the Executive Director of the Sex Abuse Treatment Center. We are in strong support of this bill. I had a whole thing prepared, but ultimately, what I would like this committee to know is that really the purpose of the statute, for this legislation is really to have the law consistent with what we know to be common for children, which is delayed disclosure. Many children don't disclose for many, many years. It is prospective in nature, giving children an opportunity to come to terms with their abuse. Some of them take much longer than others. And so it's trying to give them an opportunity for the law to be consistent with this delayed disclosure. What these civil actions actually do is that they really highlight not only what the offender has done, but it also highlights the negligence of institutions that enable offenders to have access to children to continue hurting them. And that's really what this bill is trying to address. There are many states that have eliminated the civil statute of limitations altogether. Many states are like Hawaii that have an age limit or a number of years. And we are really just trying to get the law aligned with what is happening with children. It is a little disheartening to hear some of the opposition, which continues to focus on really limiting the liability of offenders and protecting offenders and institutions that allow this abuse to go on. But I really do think that it's an opportunity to change the narrative. We need to change the narrative by putting children first, by saying, yeah, there are some challenges to extending the statute of limitations, for sure. But those challenges exist not only for the victims and survivors who are bringing suit, but really it is an opportunity to say that is part of the consequences when you lay hands on kids that you shouldn't be doing. And so really it's just trying to change the narrative in what is happening. And so we would ask this committee to pass this bill as is. So thank you.
Thank you very much. Next, we have testimony and support from the Hawaii Association for Justice. Next, we have testimony and support from the Stonewall Caucus of the Democratic Party of Hawaii. Mr.
Good afternoon
Goloyu.
again, Michael Gloria Jr., Chair of the Stonewall Caucus, the Democratic Party of Hawaii. We stand in strong support of this measure. I know we asked in our written testimony for amendments because we want to go on record as that we don't believe there should be any statute of limitations when it comes for survivors of childhood rape. We know, unfortunately, we know that that has not been the will of this body. So we are able to agree with that. This is again, a compromise with what the bill you have before us. And we can stand in strong support because survivors of childhood rape need the time to heal, to come to terms with somebody destroying their childhood by raping them, and then being protected by the entities that allowed this to happen. We have seen that time and time again. Hawaii has had to come to terms with that from multiple different organizations, and I'm not going to name them out of deference to the chair. But I do want to look at the insurance companies in testimony and say that, again, when we had this pilot project that sunset in 2020, it did not cause any of the child care providers to go out of business. The insurance companies did not jack up their insurance rates. We do not see that happening on the continent when they got rid of the statute of limitations entirely in those jurisdictions. So the sky is not going to fall. It is going to provide survivors of childhood rape the opportunities to, again, go after their perpetrators and those that allowed it to happen. I believe the state has a lot of safeguards in place, so that should protect the state from any of these lawsuits. And maybe the AG should be talking to those departments to making sure that all the protections are in place, so no child has to go through this. So believe survivors, protect survivors, and give survivors a voice. Thank you.
Thank you very much. We have testimony in opposition from the Hawaii Insurers Council. Testimony in support from Rainbow Family 808. Testimony in support from the Democratic Party of Hawaii. Testimony in opposition from the Church State Council, which I think is related to the Seventh-day Adventist Church. Testimony in support from the Hawaii Public Health Institute and from HCAN Speaks and Hawaii State Coalition Against Domestic Violence. Testimony in support from Cheryl Hoke, H-A-U-K, not present. Testimony in support from Carolyn Goloyu, not present. And then testimony in support from another group of 16 individuals. Is there anyone else wishing to testify in Senate Bill 2601? If not, questions, members? No questions? If not, thank you to the testifiers. We'll move on to the next measure. Senate Bill 2397, relating to the Hawaiian Homes Commission Act. This measure excludes from any waiting list maintained by the Department of Hawaiian Homelands any lessee or successor who sells or transfers their lease on a tract of Hawaiian homelands for personal gain. The measure establishes that the Hawaiian Homes Commission shall have a right of first refusal for the sale or transfer of a lessee's interest in the lease when the sale or transfer is for personal gain. First up, we have testimony from the Department of Hawaiian Homelands. Welcome, Oriana.
Aloha, Chair, Vice Chair, members of the committee. The department stands on its written testimony with comments. The department currently holds the position that this measure is unnecessary and premature. It's unnecessary because there's a very small percentage of waitlisters who basically treat the waiting list as a revolving door. But just because it's a small percentage, that doesn't mean that it should be dismissed or not addressed. So the commission called for a PIG, or Permitted Interaction Group, to be formed to investigate and make findings and conclusions concerning this matter. And that PIG is meant to report their findings to the commission in May. So that's why it's premature. Thank you for the opportunity to provide testimony, and I'm available for questions.
Thank you very much. We have testimony in opposition from the Center for Hawaiian Sovereignty Studies, Ken Conklin, and testimony in support from Luann, Mahiki, Langford, Favorito. Is there anyone else wishing to testify on Senate Bill 2397? If not, questions, members? Just one question for the Department of Hawaiian Homelands. In your testimony, you indicated this is a very small number. Do you have any idea of how many you're talking about here? I guess you did say actually half of 1% of pastoral agricultural applications and 4% of residential applications. Is that correct?
Yes, that's correct. And you can read more about it in the report that is attached to our testimony.
So if we have members of the public watching this that are interested in this, urge them to look at your testimony, get the link, read the report, which was a report to the 2020 legislature. And then if they're interested in the work of the Permitted Interaction Group, would we direct them to later in your testimony where you have the approved minutes of the Hawaiian Homes Commission on September 18th and 19th, 2023 for details about that?
Correct.
Okay. So I think there's a great deal of interest in this, but I think, as you say, perhaps the numbers are very small, albeit it's still important to address. And so if people are interested in finding out more, those would be the locations of the resources.
Yes.
Yeah, okay, great. Well, thank you very much for your information, and I appreciate your working on this. And if there is some recommendation that comes from all this, we'll look forward to it next session.
Okay, thank you.
Thank you. Any other questions, members? If not, let's move on to the next measure. Senate Bill 2591 relating to burial sites. This measure imposes a fine on any landowner that fails to disclose or record the existence of burial sites or archaeological sites on their property to the Bureau of Conveyances that the landlord knew or should have known of. On this measure, we have testimony from the Office of Hawaiian Affairs. Welcome. Please introduce yourself and proceed.
Yeah. Hello, Chair, Vice Chair, members of the committee. My name is Kamakana Ferreira. I'm the lead compliance specialist with the Office of Hawaiian Affairs. We stand in strong support of this measure. But just to highlight a bit from our testimony, already in the administrative rules, there is a requirement to record burials with the Bureau of Conveyances. But in OA's experience, we've observed that sometimes this goes overlooked, and it does create problems in the future, especially when certain descendants expect access from one landowner or certain protections that are allowed, and it doesn't get passed on to the next one. And so sometimes that can end up in litigation that can be costly, and so we think this this proposed measure is a good step forward. Thank you.
Great, thank you very much. Next, we have testimony and support from Dr. Downer with the Department of Land and Natural Resources. Welcome, sir. Please proceed.
Aloha, Chair. I'm Alan Downer, Administrator of the State Historic Preservation Division. The department stands on its written testimony and support. On a regular basis, we are contacted by property owners who want to know why we've required, for example, an archaeological inventory and survey before they can get a permit. And we tell them frequently, listen, we know there's an archaeological site there or there's a burial site there. And they'll go, well, we didn't know. And as Kamakana just said, the rules already require that these things be recorded with the Bureau of Conveyances, but we don't have the capacity to check to see if that happens. We just don't have the resources to do that. And there's no disincentive. So if somebody doesn't do it, so what? You know, as the law stands now, they're home free. Well, the rules say they have to do it. There's no penalty for failing to do so. And a person who is buying a piece of property ought to know what they're getting. And we, you know, particularly burial sites, do come with some restrictions on what you can do to the land. So the department stands on its written testimony and support. Happy to answer any questions.
Thank you very much, Dr. Downer. Next, we have testimony and support from Malama Makua and testimony and support from Keone Shizuma. Is there anyone else here or online wishing to testify on Senate Bill 2591? If not, questions, members? No? Thank you very much. We will move on to the next one, Senate Bill 2640, relating to the Hawaiian Homes Commission Act. This measure amends the Hawaiian Homes Commission Act to authorize the Department of Hawaiian Homelands to provide cash awards to beneficiaries on the wait list in lieu of a lease. It requires the Department of Hawaiian Homelands to remove those beneficiaries from the wait list and specifies that beneficiaries who accept a cash reward shall lose their right to return to the wait list, but remain entitled to other rights provided by the Hawaiian Homes Commission Act. It takes effect on either the date of the Secretary of the Interior's notification that congressional approval of this act is unnecessary or on the date of consent by the U.S. Congress. First up, we have testimony from, we'll hear first from the Department of Hawaiian Homelands.
Aloha, Oriana Leao Ko'inoa from DHHL. The department stands on its written testimony with comments. We are currently utilizing a multi-pronged approach toward tackling the waiting list, and we remain open to other ideas that will help us to do that. However, at this time, cash awards are not on the table before the commission or beneficiary consultation, and I'm available for questions. Mahalo.
Okay, thank you. Next, we have Deputy Attorney General Jordan Ching. Welcome, please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. The Deputy Attorney General Jordan Ching, on behalf of the Department of the Attorney General, we have comments on this measure. The measure currently provides that the department may expend funds from the Hawaiian Homelands Fund, Hawaiian Home Loan Fund, I should say, to pay for the proposed cash awards. The Hawaiian Home Loan Fund is established under Section 213B of the Hawaiian Homes Commission Act, which sets forth the various allowable uses of that fund. For purposes of clarity, we recommend adding a new Section 3 to the bill that would expressly specify or amend Section 213B to add cash award payments as an allowable use of the fund. I can be available for more further questions after.
Thank you very much. And we've received testimony in opposition from Ken Conklin with the Center for Hawaiian Sovereignty Studies, and testimony in support from 3 individuals. Is there anyone else wishing to testify on Senate Bill 2640? If not, questions, members? I have a question for the Department of Hawaiian Homelands. Thank you for being here. This measure, if it were to pass, authorizes the Department of Hawaiian Homelands to provide cash awards. It doesn't mandate it, but it would just be an authorization, of course, with the approval of the federal congressional approval if necessary. I recognize that you said that it's not on the table now. It has not been considered by the commission. Has the commission or does the leadership in Hawaiian Homes have an objection to even considering it? Is there, I mean, if we were to authorize you, you'd have to go through your process to determine, the commission would have to weigh in and decide if we're going to do this, how would we do it, what were the parameters, what were the guidelines. But I just am trying to fathom whether or not there's any philosophical opposition to something like this.
This current proposal has not been an agenda item on a Hawaiian Homes Commission meeting yet. I cannot state what the commission would choose or vote. I do think it is an important question to keep in conversation. However, speaking to your question of a question of whether or not the department would support its philosophy, currently we offer lots for residential, agricultural, and pastoral use because the intent of the Hawaiian Homes Commission Act was to connect beneficiaries back to the land.
And then the other question I've gotten from some members is, should there be restrictions on how this money could be spent? Let's say if the money is given that they are to purchase property, and right now there's no restriction as to how that money would be spent. To me, it seems like that should be left up to the commission, and they could decide if the money have any strings on it.
I think the commission would concur. I think as the bill is currently written, cash awards could be used for rent payment, mortgage payment, and down payment for a home, but there would probably be a cap for that amount.
Yeah, I recognize the need for the commission to have decision-making authority over a lot of these things, but I appreciate what you're able to tell us about the overall philosophy of the department. Thank you very much. Any other questions, members? If not, thank you very much for your testimony. Okay, next, let's move on to Senate Bill 3109, relating to the Department of Hawaiian Homelands. This measure gives practical effect to the intent of the legislature that funds appropriated in Act 279, Session Laws of Hawaii 2022, be available for expenditure until June 30th, 2025. And it also appropriates funds. First up, we have the Department of Hawaiian Homelands.
Aloha, the department stands on its written testimony in strong support of this measure with our noted amendment. As you are well aware, we had a wonderful Act 279 working group meeting yesterday where we were able to articulate and confirm our progress with Act 279. And if we need a little bit more time, this bill will allow us to honor the legislative intent of Act 279. Thank you.
Thank you very much. Next, we have testimony from the Office of Hawaiian Affairs. Welcome. Please proceed.
Aloha, Chair, Vice Chair, members of the committee. My name is Ke'opu Relitz. I am the Director of Advocacy with the Office of Hawaiian Affairs. We stand in support of this measure and defer to DHHL on any amendments that may be needed for effective implementation. Mahalo, and here to answer any questions.
Thank you. And next, we have testimony and support from the Department of Budget and Finance. And testimony with comments from the Tax Foundation of Hawaii. Is there anyone else wishing to testify on Senate Bill 3109?
Thank you, Chair. Tom Yamachika.
Oh, there you are, Mr. Yamachika. Please proceed.
Thank you. The foundation does recognize this bill as a technical fix. I'd be happy to answer any questions. Thank you very much.
Thank you. Anyone else wishing to testify on Senate Bill 3109? If not, questions, members? Seeing none, we'll move on. Thank you very much to the testifiers. Senate Bill 3123, relating to access to vital records for the Department of Hawaiian Homelands. This measure authorizes the Department of Hawaiian Homelands to access vital records for purposes of verifying Native Hawaiian ancestry for beneficiary programs. It requires the Department of Health and the Department of Hawaiian Homelands to enter into a memorandum of agreement to assure appropriate access and handling of confidential records and sealed records that have been unsealed pursuant to court order. On this measure, we first have let's have the Department of Hawaiian Homelands go first.
Aloha mai. The department stands on its written testimony in strong support of this measure. As you are aware, you must be 50% Native Hawaiian to be awarded a lease, and you must be at least 25% Native Hawaiian according to the blood quantum requirement. Access to vital records helps us to ensure and qualify lessees and successors and transferees. And we also have a MOA with DOH right now, and it's being finalized. So thank you, and I'm available for questions.
Thank you. Next, we have testimony from the Department of Human Services in support. Testimony from the Department of Health in support. Welcome. Please introduce yourself and proceed.
Vilina Mai, Chair Tarnas, Vice Chair Takayama, and members of the committee. I am Wanda Naionishi from the Department of Health. We stand in strong support of SB 3123 SD2. Enacting the bill will help the Department of Hawaiian Homelands place Native Hawaiian beneficiaries on homestead lands, and we stand on our testimony. As you mentioned, the bill is to authorize Hawaiian Homelands to access these vital records for purposes of verifying Native Hawaiian ancestry, and it requires that MOA to be entered into by the Departments of Health and Hawaiian Homelands. The MOA has been finalized, signed on both sides. To get a better idea of how involved the access to records will be for researching one's genealogy, I brought an example of one of the vital records that may be used. It is a marriage registry from Molokai between 1850, when Kamehameha III was king, through 1877, during King Kalakaua's reign. Every entry, let's see, I think I have it upside down. Every entry is handwritten, listing the marriage date, names of the spouses, and the town in which the couple lived, and that's about it. But this is just one piece of the puzzle to link the beneficiary to their Hawaiian ancestors. The other pieces will involve birth and death records that offer similar types of information. And once we put all these pieces together, the Department of Health can help the Native Hawaiian beneficiaries access those homestead lands. So mahalo for allowing me to provide testimony.
Certainly. Thank you for your testimony. Next, we have testimony from the Office of Hawaiian Affairs. Welcome. Please proceed.
Aloha again. Director of Advocacy, Keopu Relitz, and we again stand in support of this measure and defer the DHHL and the Department of Health on any amendments that may be needed for effective implementation. Mahalo.
Thank you. And we have testimony in support from Luann, Mahiki, Langford, Favorito. Is there anyone else wishing to testify in Senate Bill 3123? If not, questions, members? I have a question for probably Department of Hawaiian Homelands. You can tell us the memorandum of agreement. Could you briefly describe what that is between Department of Hawaiian Homelands and Department of Health? And what is this interagency process that you're seeking to streamline? And how long before you think it will go into effect? You may not be able to answer the second question, but describe what the memorandum of agreement is going to cover.
So currently, I believe we do batch requests, and there's a fee that's attached to the batch request, and our current turnaround time is about 3 to 4 weeks. But when this MOA is implemented, we will be able to streamline and cut that time probably in less than half. Also, it will allow us to have free-range access to their vaults and other documents that were noted by the DOH in their testimony. Because we have very special cases of adoption. Sometimes it's closed, sometimes it's open. So this will help us to streamline the process and provide a greater efficiency for our beneficiaries.
So I understand that thank you for that information. I understand the MOA has been signed, according to the testimony from the Department of Health. Is it close to being able to be implemented?
Yes, but I can't provide an accurate amount of time from when it gets signed to when we can.
Sure.
Yes.
Does it require Hawaiian Homes Commission approval?
I don't believe so, but
Okay.
I don't think that turnaround time would take too long either.
Okay. Okay. Thank you very much.
No problem.
Any other questions, members? If not, thank you very much to the testifiers. Let's move on to the next measure. Senate Bill 3363 relating to Hawaiian Homelands. This provides that a living beneficiary's place on the Department of Hawaiian Homelands wait list for any residential, agricultural, or pastoral tract may be designated for transfer to a successor if the living beneficiary dies before receiving an offer for a tract. It also provides that it is provided that the successor shall be at least 1/32 Hawaiian. On this measure, first up, we have testimony from the Department of Hawaiian Homelands. Thank you for being here today.
Aloha, no, the department stands on its written testimony with comments on this measure. We appreciate the intent of this measure. However, it is in conflict with HRS 10-3-7, which notes that we have historically awarded awards in chronological order according to application date and not based on when an applicant passes away. And I'm available for any questions.
Okay, thank you very much. Next, we have testimony from Ken Conklin, Center for Hawaiian Sovereignty Studies in opposition, and testimony in support from Keone Shizuma, and testimony with comments from individual DKQ. Is there anyone else wishing to testify in Senate Bill 3363? If not, questions, members? I have a question for the Department of Hawaiian Homelands. So you're saying that this proposed measure is in conflict with your rules? Is that right?
Correct. Yes.
So what would happen if the legislature decided to pass this? How would those be reconciled? That was a big sigh.
The waiting list is in direct correlation with our administrative rules, so HAR 10-3-7 and possibly other sections would have to be amended. The commission would also have to approve after review. There's also a section of this bill which speaks to blood quantum, and that would award a lease to a successor of someone who has passed away while on the waiting list, as long as they're 132nd. Now, we're grateful that SCR 104 did pass in the state, but I cannot promise that it will pass in Congress.
And the reason why you bring that up is that it requires congressional action to change the blood quantum level?
Yes, correct. So the waiting list is in direct correlation to the administrative rules, and the blood quantum requirement is in direct relation to the Hawaiian Homes Commission Act.
Okay. Okay, thank you for that explanation.
No
Any other
problem.
questions, members? If not, we'll move on. Thank you. Next, Senate Bill 3159 relating to contested cases. This clarifies that a contested case hearing is not required when a tribunal has already issued a final decision and order in a contested case proceeding arising from the same factual situation that was not appealed, or where a court of last resort has already issued a final decision on the proceeding or on other substantially similar matters. On this, we have testimony from the Department of Land and Natural Resources.
Good afternoon, Chair, Vice Chair, members of the committee. Russell Tsuji, speaking on behalf of DLNR. As you, I hope you've received our written testimony
Yes.
seeking an amendment, asking this committee to go back to the original version of the bill, which we prefer. And I explained the reason of that in our testimony, between the situation where you have a hypothetical situation of a building A owner complaining about an agency allowing another building to be built, building B, in front of its building and claiming its view plane being blocked. The example I cite is where you have a fully adjudicated case, and in that case, the administrative agency would decide, if they decided that the owner in building A did not have a legal right for a view plane to see that, and therefore not a legal right. What we're trying to prevent is another building owner with a different floor, with a different view plane, coming back with the same type of contested case request, claiming its view plane is being blocked by building B. And that's what we're trying to encompass to make sure we can stop the seemingly endless litigation. If I may, Chair, at this time, I looked over the testimony submitted by my esteemed colleagues, and I've read the cases that they've cited, and I do not believe they apply. Number one, Flores, in the Flores case, that case clearly decided that under Flores, he was not entitled to three. Number one, he was not entitled to a contested case by statute. He was not entitled to a contested case by administrative rule. And third, he was not entitled to a contested case by the Constitution, and therefore it held that way. In the other cases cited by Mr. Fisher from San O'Toole, as well as Isaac Morikawa, they cite another Hawaii case. I believe it was a Santos case. But in that case, Chair, it was the distinguishing factor from the scenario I'm trying to address versus that case was in the Santos case. It was a fully adjudicated administrative proceeding, and then subsequently a lawsuit being filed by the disgruntled claimant, and where the court, the circuit court judge, invoked the doctrine of collateral estoppel and res judicata. The scenario that this bill that we're proposing is trying to address a situation where the administrative body, like in this case could be the Board of Land and Natural Resources, the Water Commission, or the Land Use Commission, could decide that a subsequent case, contested case, is similar enough that it's already been covered by the first decision, and it therefore will dismiss the contested case. To the extent that my opponents or people opposing this bill is saying that it might prevent any kind of due process rights, we're actually trying to offer up due process where we believe if anybody is disgruntled by the agency decision, they will still have all the rights to appeal to the circuit court or the Supreme Court to argue that their rights of due process were violated and therefore they should be entitled to a contested case. We're not trying to eliminate that, but we're just trying to address a situation where the administrative body in a Chapter 91 proceeding is able to utilize this doctrine of the same case being litigated again a second time. I hope I was clear enough. If you have any questions, I'm here available to answer any, and I believe Ian Hirokawa in the room will also answer questions if you have it.
Thank you very much. Yes, Mr. Hirokawa is here in the room. Appreciate your testimony, Mr. Tsuji. Next, we have testimony in opposition from Isaac Moriwaki with Earth Justice. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee. Isaac Moriwaki, not Morikawa, from Earth Justice. So I think we testified on this a week or two ago, and at that point, it was only me. I was raising some concerns. There was a little bit of a head scratcher. Spidey sense was kind of going off, tingling a bit. And Chair, you suggested that we get together with DLNR, try to figure out what's going on here. So I did that in good faith. And I can say straight up at this point, this bill is just up to no good. And it should be killed. I mean, we tried to reach out to DLNR and figure out, can you be transparent about what you're actually trying to accomplish here? I shared the established case law from Hawaii Supreme Court that we also provided in our testimony. Can you explain what is your goal? And we really got no helpful response. And I don't even know what Mr. Tsuji was trying to explain there. He was basically talking bubbles to my sort of legal training ear. And so it's basically a lot of dodging and reaching to a level of gaslighting like I really don't understand. And it's clear from the testimony, though, in support, and then trying to go back to the original language of the bill. And I appreciate Senator Rhodes trying to clean that up and tighten it up a bit, but as we explained in our testimony, it really is kind of the same concern. It's overbroad, it's not consistent with the case law, and I want to make clear, Earth Justice is not working with the Starn firm on this. We're in totally different fields, but we spot the same problem, and thank you very much for the Starn firm to point out that this violates constitutional due process. It's just way out of whack, not aligned with established case law, but again, the bottom line is, what's the need? We just don't see it, and based on the testimony and these discussions, it's clear that this bill is up to no good, so we respectfully ask that you hold the bill. Thank you.
Thank you, Mr. Moriwaki. Next, Wayne Tanaka, Sierra Club, in opposition. Aloha.
Aloha. Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. Wayne Tanaka with the Sierra Club of Hawaii. We are strongly opposed to this bill. We have very serious access to justice concerns about this measure's implications. I think the DLNR's treatment of our own contested case requests over the last few years really illustrates their willingness to bend the law and disregard due process in favor of administrative convenience. And this has created a huge mess, not just for us, but with this measure, by encouraging that kind of practice and policy, you may be creating a huge mess for lots of other folks, including the little guys, right? Just case in point, in 2020, we requested a contested case hearing over the revocable permits for East Maui. The DLNR denied us. 2021, the environmental court judge said, actually, yes, you have to have a contested case hearing. This was in May of 2021. We didn't have a single pre-hearing conference for months, not until the end of October, and we didn't even have an evidentiary hearing until December of that year. That's like half a year, right? And by the time this case got to appeal, it was mooted out because these permits are year to year, or last for 1 year. In 2022, we again requested a contested case hearing. We were denied. 2023, the environmental court judge said we're clearly entitled under the Constitution to a contested case hearing, that their denial of our request offends the Constitution. To this day, and this was in June, July of 2023, to this day, so again, more than half a year later, nothing has started with regards to the contested case hearing. So with a measure like this, by essentially encouraging the DLNR to continue this practice, it's going to have a huge chilling effect, not necessarily just for the Sierra Club, but for other folks who want to assert their rights, who have a right to due process, who will be forced to take the time and money and expense of litigating just to, just to vindicate their constitutional rights. And so, really happy to answer any questions, but really want to encourage you to hold this measure, avoid creating a big mess, for the DLNR, for our courts, and for the people. Mahalo nui.
Thank you very much. Next, we have testimony from Henry Curtis, Life of the Land.
Aloha, Chair Tarnas, Vice Chair Takayama, and members of the committee. I'm Henry Curtis, Executive Director of Life of the Land. This appears to be covering a lot of different agencies rather than just DLNR. I know the Hawaii Supreme Court ruled in Peahu in 2022 that if environmental issues or constitutionally protected public trust issues are decided by other bodies, the Public Utilities Commission can defer to those other bodies. But if there are serious issues raised by interveners on these issues, then the Public Utilities Commission must issue findings of fact on those specific issues to protect the constitutional right to public trust issues. So this raises constitutional issues that I think a very narrow bill is still wrong, but we oppose the bill totally. Thank you.
Thank you. Next testimony from the law firm Starn, O'Toole, Marcus, and Fisher. And testimony in opposition from David Kimo Frankel. Is there anyone else here wishing to testify in Senate Bill 3159? If not, questions, members? Seeing none, we'll move on. Thank you to the testifiers. Next measure, Senate Bill 3226, relating to administrative procedure. This measure provides that a maximum time period to grant or deny a business or development-related permit, license, or approval shall only apply if a request for a contested case has not been filed or is required by law. First up, we have testimony and support from Hawaii County, Office of the Mayor. And that's it. Is there anyone else wishing to testify on this measure? If not, no one to ask questions of. We'll move on to the next measure. Senate Bill 3176, relating to tax enforcement, and the good director of tax is here so patiently waiting. This measure, relating to tax enforcement, provides deadlines for taxpayers under audit to comply with demands to produce documents and evidence, authorizes the tax appeal court to preclude documents or information not produced pursuant to a demand from being introduced in evidence in a tax appeal or action under Section 40-35 Hawaii Revised Statutes, unless the failure was due to reasonable cause. First up, Gary Suganuma, Director, Department of Taxation. Thank you for your patience, sir.
Good afternoon, Chair, Vice Chair, and members of the committee. Gary Suganuma, Director of Taxation. I am aware that you're already familiar with this measure. The companion to this bill, which was HB 2487, was heard by this committee and deferred. And so I realize I may be fighting an uphill battle here, but I just wanted to highlight some things. I mean, to the extent that your concerns regarding this measure is due to the issues that are contained in some of the pieces of written testimony in opposition to the measure, then I'd like to address that. So, as you're aware, what this measure seeks to do is it seeks to establish a deadline for taxpayers to respond to information requests during an audit. So right now, there is no statutory deadline. And so what this does is it establishes, the original bill established a 20-day deadline, and then Senate Ways and Means amended the measure to make it 30 business days. So right now, the current version of the bill has 30 business days. The significance of that is that under Section 231.35, any person required to supply information under Title 14, which is the tax section of the statutes, who willfully fails to supply information at the time or times required by law shall be guilty of a misdemeanor. So currently, right now, when we have taxpayers that completely ignore our request for information during an audit, the Attorney General's office really can't pursue criminal charges under this statute because currently there is or are no time or times required by law for them to respond. And so what this would do is it would create a statutory deadline and a time required by law for them to respond. And if they don't respond, then the Attorney General would have the authority to bring charges, which we think would be a really big incentive for these taxpayers to actually cooperate and work with us during the audit. If they don't provide us with information during the audit really is meaningless, right? I mean, we can issue an assessment based on best available information, but really, the audit process is supposed to be an opportunity for us to obtain information so that we can make an accurate assessment of what the tax liabilities are for the taxpayer. And when the taxpayer doesn't cooperate, that's impossible. So a lot of the opposition to this measure arises from this concern about 30 business days being too short for a taxpayer to respond. My response to that is that the measure here imposes 30 days or as soon thereafter as the director may deem reasonable under the circumstances. And so if a taxpayer is in communication with us during the audit and they want more time to respond, of course we're going to work with them and give them a reasonable amount of time. I would agree that there are certain requests that may require way more than 30 days to provide. I mean, we may be asking for thousands and thousands of documents. Of course, we're going to work with them and give them a reasonable deadline. And if we don't, then they can go to court with this, and they can get a court to determine, you know what, you guys are being unreasonable. You didn't give them an extension. So there is that safeguard within the measure in terms of the time. So whether it's a 20-day deadline, 30-day deadline, 45-day deadline. The important thing to note is that it does have this language in here that protects the taxpayer, right? It is however many days or as soon thereafter as the director may deem reasonable under the circumstances. So, okay, the other issue that has come up in the testimony is that the sanction for not responding within 30 days. So it could result, one, it could result in a referral for criminal charges, and two, any taxpayer who doesn't respond with requested information during the audit within the time required may be barred from using it in a subsequent court proceeding. But again, in that case, there is still language here that the taxpayer would be barred from using the information unless it is shown that the failure is due to reasonable cause and not neglect or refusal. So again, when a taxpayer is communicating with us and working with us, now that's not what this measure is meant to address. If they're working with us and they tell us if we can't respond within 30 days, business days, because whatever, I'm on a trip, I'm sick, if we don't give them that extension, I would submit that's reasonable cause, and the court is going to call us on it all day long. So this really isn't, so really what this measure is meant to do is it's really meant to address the taxpayer that completely ignores us. Completely ignores us. And in that case, then at least we have a way to discourage that kind of conduct, right? This would discourage that conduct. This would encourage people to do what they're supposed to do. They're supposed to be willing to share the information with us during the audit. So with that, I'm available for any questions.
Thank you very much. Next, we have testimony with comments from the Tax Foundation of Hawaii. Mr. Yamachika.
Thank you, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation. I think the director did sum it up. This bill before you today is very similar to the House version of this administration bill that this committee had previously deferred. The only difference is 20 days versus 30 business days. Now, we somewhat sympathize with the director's frustration with, taxpayers who are uncooperative. We don't think that most taxpayers are that way. But we are very concerned about having, for example, requests for information that are of questionable relevancy, that are ambiguous, that at least within the system of a court proceeding and discovery, there are mechanisms to figure out what are valid and invalid discovery requests and what's relevant and what's not relevant, or what's reasonably calculated to lead to discoverable evidence. The department here has nothing of the sort, and they just say, trust me. So that is kind of why we're concerned about this, and we'd be happy to answer any questions.
Thank you very much. Next, we have testimony in opposition from the Council on State Taxation. Stephanie Doe, please proceed.
Apologies, I was on mute. Thank you, Chair Tardis and members of the committee. My name is Stephanie Doe, and I'm a senior tax counsel at the Council on State Taxation, also known as COST. COST is a nonprofit trade association based in Washington, D.C., with an independent membership of over 500 multi-jurisdictional corporations, many of which have business operations and activities in Hawaii that would be negatively impacted by this bill. And our objective is to preserve and promote the equitable and non-discriminatory taxation of multi-jurisdictional businesses. We oppose this bill, and you have our written testimony detailing why this bill should not move forward. But I just want to use this time to make 2 points clear. To address the department's testimony, this bill is not about audit cooperation. This bill is about creating an unreasonable and arbitrary penalty on all taxpayers. To preclude use of documents and records that didn't make this arbitrary 30-day timeframe during an audit is severe and a blunt penalty for all future tax appeals in a way that diminishes the transparency and trust in Hawaii's tax administration. And a taxpayer would have to either put their blind faith in the department to work collaboratively during an audit or fight this in court to figure out what's considered a reasonable circumstance. And second, this bill stacks the deck against all taxpayers. It's not consistent with reasonable audit processes and isn't consistent with the practical considerations of document production during an audit. And I'm happy to share examples if that would be helpful to demonstrate. The bottom line is we understand the department's frustrations, but to be very clear, audits are frustrating and a difficult process for everyone involved. And that doesn't mean that Hawaii should penalize taxpayers for being a part of that process. And if the department is open, I'm certain many taxpayers, including COST, would gladly participate in future discussions on this bill as stakeholders to work through the department's concerns. For that reason, I respectfully urge this committee to issue an unfavorable report on this bill. Thank you again for your time.
Thank you very much. And we have testimony from 3 individuals in opposition. Is there anyone else wishing to testify on Senate Bill 3176? If not, questions, members? If not, thank you very much to all the testifiers. Let's go ahead and move into decision making. Back up to the top of the agenda. Senate Bill 2520. On this measure, I would like to make some changes. So this would be House Draft 1. We're going to be making some changes to the preamble to incorporate some of the substantive provisions in there as findings rather than under the purpose paragraph. That would be better crafted. So that'll be the first change. We'll also make some amendments to clarify that the new section only applies to the defense of professionally licensed or certified state employees, not all state employees. And we will also include clarifying language under subsection C on page 4, lines 9 to 19, to remove conflicting language. It's poorly crafted. So we're going to modify some of the language in that section to make it clearer. And then we'll defect the effective date to the year 3000. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2520, SD2 with amendments. Chair and Vice Chair vote aye. Representative Evslin?
Aye.
Representative Ganadin?
Aye.
Representative Holt? Aye. Representative Ichiyama? Aye. Representative Ilagan?
Aye.
Representative Kong?
Aye.
Representative Miyake?
Aye.
Representative Souza?
Aye.
Chair, your recommendation is adopted.
Thank you. Next bill, Senate Bill 2683, relating to defamation. On this measure, really is only protecting individuals, and we use that term individuals. And so there's a couple of other terms used in this bill, such as "and good faith reporters" or "person." I want to change those to, I want to delete the words "and good faith reporters" on page 1, line 5, and I want to change the word "person" to "individual" on page 2, line 10, just to make it consistent throughout. Also defect the effective date. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 2683, SD1 with amendments. All members being present. Any reservations or noes? Recommendations adopted.
Thank you. Next bill, Senate Bill 2758, Senate Draft 1, relating to sex trafficking. I'd like to amend this, adopting the Attorney General's suggestion to expand the time limit to a maximum period instead of making it open-ended with no limitation. Currently, this section of the Hawaii Revised Statutes states that a claim under this chapter may not be brought against a person more than 6 years after an act of promoting prostitution by coercion or sex trafficking by that person. I'd like to expand that an additional 4 years to a total of 10 years. I would also like to take the suggestion by the Attorney General that we retain the original tolling provision under subsection B. And I'd like to make technical amendments and defect the effective date. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2758, SD1 with amendments. Any reservations or noes? Recommendations adopted.
Thank you. Senate Bill 2439, relating to the limitation of actions. On this measure, I'd like to make some amendments. I want to change the period back to 1 year. That's currently 4 years in this draft, but I want to go back to the original time in the bill, which is 1 year, line 5, page 1. Also, I want to amend HRS 657-1.8 to incorporate the new provisions of this bill. That is a better way to craft this legislation. I also want to create bright lines for the expansion of the statute of limitations. It's currently 6 years, and I'd like, as was suggested by the Attorney General, I want to expand it to 15 years. And so the language would be similar to something like this. During the 1 year window to file a civil action, a person can bring a claim for any sexual assault that occurred after June 30th, 2009 would be permissible. I'd like to add a sunset provision that is 1 year after the effective date and make technical amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 2439, SD1 with amendments. Any reservations or noes? Recommendations adopted.
We defected the date. Yeah, I defected the date on that one as well.
Recommendations adopted.
So I want to make it clear, I defected the date on that one. Yep, okay. Okay, next one, Senate Bill 2601, relating to sexual abuse of minors. On this measure, I'd like to just make it clear that this is prospective only. It's stated that in the earlier part of the bill, but it's not exactly clear in the text of the bill. So I want to do that by adopting the language we passed out in House Bill 1968 HD2. and incorporate that so remove the contents of this bill and insert the contents of HB 1968 HD2, which is a measure that we passed out of this committee. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 2681 with amendments. Any reservations or noes?
2601.
2601 with amendments. Any reservations or noes? Recommendations adopted.
Thank you. Next measure, Senate Bill 2397. I'd like to take the recommendation of the Department of Hawaiian Homelands that they're working on this. There's a report that is being conducted by a permitted interaction group which is expected to be completed in May. And so I look forward to the results of that. And if there's any necessary legislation, we can come back next session and work on that. So my recommendation is to defer Senate Bill 2397. Questions or concerns, members? If not, we'll move on. Senate Bill 2591 relating to burial sites. On this measure, I'd like to make amendments. I'd like to adopt the Department of Land and Natural Resources amendments that they suggested. I would also like to, on page 1, line 11, I want to make it clear that the fine applies to a private landowner, since that's really the intent of this bill. I'd like to make technical amendments for clarity, consistency, and style, and defect the effective date to year 3000. Oh, yes, yes. Thank you. And I want to make it clear that it's the court that has a jurisdiction to impose the fine, because that was a question that was brought up in the DLNR testimony, and they left it open. And that we would deposit the fines into the historic, what was it called? The Historic Preservation Special Fund. Thank you. Yeah, sorry for those. So there's two other things. It's the court of competent jurisdiction will impose the fine. They have the duty to impose the fine, and that the fines will be deposited into the Historic Preservation Special Fund. Okay? And we defect the effective date, year 3000. I've got a great crew helping me out here. Thank you. Those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2591 SD2 with amendments. Any reservations or noes? Recommendations adopted.
Okay, next measure, Senate Bill 2640. On this measure, I would recommend that we adopt the Attorney General's amendments, make technical amendments, and defect the effective date to year 3000. And let's keep this conversation going, recognizing that it's got to go to finance, and even if we do pass it out, it needs to be discussed and approved through action of both the department and the commission. But let's keep the conversation going. So that's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2640 SD2 with amendments. Any reservations or noes? Reservations for Representative Ganadin. Recommendations adopted.
Thank you. Senate Bill 3109 relating to the Department of Hawaiian Homelands. This is a very important measure. I'd like to adopt the recommended amendments from the Department of Hawaiian Homelands and make technical amendments and move out House Draft 1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3109 SD1 with amendments. Any members with reservations or noes? Recommendations adopted.
Thank you. Next bill, Senate Bill 3123 relating to access to vital records for the Department of Hawaiian Homelands. I recommend we move this out with technical amendments and defect the effective date to year 3000. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3123 SD2 with amendments. Any reservations or noes? Recommendations adopted.
Thank you. Senate Bill 3363, I'd like to move this out with amendments. It's going to finance next. The amendment I want to make is that we need to ensure that we put language in there that says, provided that the successor of the beneficiary who died is Native Hawaiian as defined by the Hawaiian Homes Commission Act. And that's Native with a small n. So I want to make sure that we're not creating all kinds of trouble by not making that clear. It already has a defective effective date, so that's my recommendation to move that out with amendments. Questions or concerns, members? Representative Gannon.
Chair, I'm going to be voting no. I think that try as we might, we're not Congress. I think states across the country have had issues with trigger legislation. Although the conversation about blood quantum certainly has its roots in conversations about colonialism and inappropriate theft of land, I think that this is a step too far.
Thank you. I appreciate your perspective on that. Any other questions or concerns, members? Representative Souza.
I'm voting no as well, thank you.
Sure, thank you. Any other questions or concerns? If not, Vice Chair for the vote.
Voting on SB 3363 SD2 with amendments, noting the no votes of Representatives Ganadin and Souza. Any other reservations or noes? Recommendations adopted.
Thank you. Senate Bill 3159. I appreciate the spirited discussion on this from our learned attorneys. And I'm going to defer to my counterpart in the Senate on this one. He's tried to craft legislation to find something that is workable, and I want to give it a chance. So I would like to make technical amendments only. It's already got a defective effective date, and move it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3159 SD1 with amendments. Any reservations or noes? No vote for Representative Holt. Any other reservations or noes? No vote for Representative Ganadin.
No as well, thank you.
No votes for Representative Ganadin and Souza. Chair. Yeah, noting the no votes of Representatives Ganadin, Holt, and Souza. Any other reservations or noes? Recommendations adopted.
Thank you very much. Next, Senate Bill 3226. On this measure, we're going to, so we're going to remove the amendment made by the Senate GVO committee, because I think that only confused matters, with all deference to the chair of the GVO committee. But let's remove that and put in a defective effective date, the year 3000. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3226 SD1 with amendments. Any members with reservations or noes? Recommendations adopted.
Thank you. Final measure, Senate Bill 3176, relating to tax enforcement. I want to give this bill a chance, move forward. I want to just make technical amendments and defect the effective date, the year 3000. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3176 SD1 with amendments. Any reservations or noes? Recommendations adopted.
Thank you. There being no further business before this committee today, we are adjourned. Thank you, members.